As the court leaders, good morning, Your Worship. I confirm once again my appearance on behalf of applicant number 1 in this matter. May I just for the court also to affirm your Worship with the relevant rule, my learned, and I'm indebted to my learned colleague. He actually referred us to section 8 of the schedules of arrangements of the regulations that was issued in terms of Government Gazette number 53183 on the 19th of August 2025, and with reference to section 8 of the said regulations, persons appearing before the Commission, and I will just read it into the record so that the court also take notice thereof. No person appearing before the Commission may refuse to answer any questions on any grounds other than those contemplated in Section 3, subsection 4 of the Commissions Act 1947. Then the section which is applicable before Your Worship is Section 8.2, where it indicates a self-incriminating answer or a statement given by a witness before the Commission shall not be admissible as evidence against that person in any criminal proceedings, and I submit that the following is important: brought against that person instituted in any court except in criminal proceedings where the person concerned is charged with an offence in terms of Section 6 of the Commissions Act. Now, I firstly submit that what we are going to place before the court, as my learned colleague has indicated, we're not going to allege that it is a self-incriminating answer or a statement given by the said witness. Furthermore, it is also our contention that there are not any prospects of any criminal proceedings that will be brought against the said witness in court. So it is therefore my submission that Section 8.2 is actually not applicable to the said witness before court, Your Worship. So I will therefore request Your Worship's permission then to proceed by putting the said statements to the witness as the court pleases.
Okay. And then, as you were the initiator of of that issue, Advocate Van Veenhart, I'm not going to invite other role players to address me about the issue. I will make a ruling.
Thank you, Worship.
Then the court is going to be very brief with its ruling. The witness testified at the Madlanga Commission of Inquiry, and then what she said there can be used in this. She can be asked about what she said in the Madlanga Commission of Inquiry in this bail application, as bail application are or is the proceedings sui generis, where the rules of the normal trial are relaxed. Thank you. Then, Mr. Van Heerden, you can proceed.
Your Worship, the cross-examination of Mr. Van Mkhwanazi suggested that continued then?
No. I'm not going to interrupt you. I want you to proceed with your cross-examination. I'll afford him with that opportunity.
Thank you, Worship. I've got no problem in doing it that way, but as long as I will have the opportunity after Mr. Van Mkhwanazi then has finished his cross-examination, then there are aspects that crops up from his cross-examination that I will be allowed to revisit that at that stage.
Yes, proceed.
Thank you, Worship. Ma'am, okay. The identity of the two policemen in police uniform, that is a crucial aspect as far as this matter is concerned. Do you agree with me?
Police officers were identified, sir.
Sorry?
Police officers were identified, sir.
Were they identified?
The police officers, yes.
Oh. By whom were they identified, ma'am?
By themselves, sir.
Ma'am, I'm referring to the two policemen in police uniform. The mere fact that applicant number 2 has identified him, that he was on the scene, is not an admission that he was one of the two people referred to as the policeman in uniform. Do you agree with me?
I agree with you, sir.
Fine. Now that is the problem. It's of crucial importance, the identity of these two policemen in uniform. Do you agree with that?
I don't agree with you saying
Okay.
that, because the uniform can mean anything as long as it's part of the uniform of the SAPS. It's a uniform. So for a private person, they can call somebody in uniform while you were only wearing a bulletproof that is written police on top. So if you say in uniform, they are not identified. As I explained to you, SAPS, they are very good in conducting their duties, and we applaud them for that, because for SAPS members, it's not easy for them to run away from the wrongdoing, because it's easy to catch them, because everything is done according to books.
Ma'am, the two police officials, and I'll refer you to the statement of Mr. Van der Merwe before the evidence that he had used before the Mdanga Commission, and as well as far as his written statements that forms part of the docket, that he's referring to police officials in full uniform,
I'm with you, sir, yes.
and I'm referring to those two policemen.
Sir, according to Mr. Van der Merwe's statement, as I'm explaining to you, he alleged that there were police officers in uniform. Hence, sir, I am saying to you, we did our investigation. SAPS members, if they were at the crime scene, moreover, if they were in police uniform, it was going to be SAPS members that were on duty on the day. And that is Brakpan area. The officers who were on the duty must come from Brakpan police station, not from any other police station. And then the investigation, when it's done, we request for all the books of the members who were on duty on the day. So according to SAP 15, they are registered when they register their names, when they report on duty. None of the officers on that day attended to that scene. None of the officers on that day were aware of that, except for members that were already off duty, which is applicant number 2 and the deceased.
Ma'am, it is possible that police officials from other stations could have been on the scene as well. Is that correct?
Any officer can come to the scene, sir.
That's correct. So the mere fact that there's a police official dressed in uniform does not mean that that police official is from the Brakpan station.
I don't agree with you, sir. Your question was, is it possible that any officer can be on that scene? I said yes. But now when you say a uniform police officer will not come all the way from there and go out of his jurisdiction and go and attend a matter on another area, not unless he's got ulterior motives concerning to that.
Ma'am, I put it to you that it's possible for other police officials dressed in uniform that could have been on the scene.
On that scene we're talking about, say, there were no other officers that were there according to our investigations.
Ma'am, according to the evidence of Mr. Van der Merwe, there were many people, and he's not restricting himself to the 11 people that you've identified to be present on the scene.
When you say many people, you're saying there were many SAPS members. That's what you're saying.
He says there were many people, ma'am. I'm not talking about, and I'm not limiting it to police officials only, that there were many people on the scene. It could include police officials
Yes,
as well.
as applicants say, they are agreeing to that, to say there were many. I agree to that.
And ma'am, the mere fact that the person is dressed in police uniform and that this matter has happened in the Brakpan jurisdiction does not mean that it is a person related and linked to the Brakpan police station.
So it doesn't work that way. That's why there are police stations in all the areas. If ever the area is too big, they will make sure that they make sure that there is a satellite station there, so that whatever that is happening, SAPS must account. It cannot come the police station from Springs and come and attend the scene at Brakpan, the police station that is working in reliefs at Springs. Not unless the police officer is working in certain units. That officer can go there. But police officers that are working in units, their cars are having AVRs, they are being tracked. So we tracked the SAPS cars that attended to that scene. The car that was there, it's for Brakpan, as well as the car of your client.
Which car was that of applicant number 2, ma'am? Which car are you referring to?
I'm referring to as per his statement.
Yes.
It's not on the AVR. As per his statement and as per 132B where he signs. Where they sign whenever they are driving a state car.
So there was, you concede that there was another vehicle on the scene, and that was the vehicle that was being driven by applicant number 2.
According to the documents, yes.
Yes. And ma'am, you've already also conceded that as far as the AVL system is concerned, that it is not a perfect system because there are many police vehicles that's not equipped with functional AVL systems. Is that right?
That's correct, sir.
So there could have been a number of other police vehicles that could not be traced due to the fact that the AVL system is not perfect.
So what I don't agree with you is that they could have came from other stations. If you're talking about units, cars that are coming from different units of SAPS, then it's something else.
Ma'am, as far as the identity of these two police officers dressed in police uniform, what Mr. Van der Merwe labelled as members of the Brakpan police station, does it give any basis on which he came to the conclusion that they're from the Brakpan police station?
Can you repeat your question again, sir? I don't understand your question.
Which portion did you not understand, ma'am?
I want you, sir, to repeat the whole question. I won't say which portion.
No, which portion did you not understand?
Sir, I don't understand your question.
Situation is, ma'am, as far as the evidence of Mr. Van der Merwe is concerned, does he give any indication as to why he labelled these two police officials that was dressed in police uniform as being part of the Brakpan police station?
I didn't have to cross-question him on that because if ever he said that they were in uniform, I must take that they were in uniform according to him.
And from that, you jump to the conclusion that they must be from the Brakpan police station.
I didn't jump into conclusion saying each area has got its policing jurisdiction. I didn't jump into conclusion. Number 4, Crocodile Street belongs to Brakpan area. So that's the first station you must do investigation on, not any other station. So I didn't jump into conclusion.
Ma'am, does anybody mention the names of either applicant number 2, Mr. Sabandi, or that of the late Mr. Koza in relation to the identity of the police officials that were present there? I'm not talking about the admission or the statement that was made by applicant number 2 or the warning statement of Mr. Zander Fritz. I'm talking about, is there any other person that is mentioning those two people's names?
No, so there's no other statement that is mentioning their names. Yes, we've got records that they were there. We don't need anyone to mention their names.
Ma'am, and if I put it to you that as far as the applicant number 2 is concerned, and I think I've already done that, is that his evidence and the evidence on the record is, and the evidence available to you is that he was dressed in plain clothes. Is that correct?
I won't disagree to that, sir.
And ma'am, as far as his involvement in the matter is concerned then, there's not clarity because there's no reference made to what applicant number 2 or Mr. Koza did on the scene. Is that right?
Say, he's a police official. Whenever they are doing the duties, he's got an obligation to explain his availability on that area as to why was he there as a police officer. So if you say there is nothing that explains that, I don't agree with you because he disposed a statement as a person who was officially on duty according to himself.
Ma'am, you've got access to the statement of applicant number 2. You've got access to the warning statement of Mr. Zander Fritz. And both of them confirm that there was a WhatsApp group that a message was placed on, and where assistance was asked from members of the South African Police to assist in this matter, where the investigation was going to be carried out at the scene where this incident happened. Is that right?
According to their statements, yes, sir.
And as far as that is concerned, that is how he arrived on the scene, and that is what he did on the scene. And he doesn't know any, he did not participate in any torturing or assault on the deceased. And that is confirmed in the statements that you received from applicant number 2 and Mr. Zander Fritz. Is that right?
According to their statements, sir.
And there's nothing to contradict that, ma'am.
It's Mr. Marius van der Merwe's statement that is telling something different from what they are explaining, sir. It is written there on Mr. Marius' statement, sir.
What did Mr. Marius van der Merwe say that applicant number 2 do, ma'am?
Can I go back to his statement, sir?
And I need specific reference where he mentioned the name of Mr. Sabandi.
As I said, sir, he didn't know the names of the officers who were there, but the police officers who were there, they were later identified. Hence, they disposed their statements.
Ma'am, Mr. van der Merwe only refers to 2 unknown.
That is very correct, sir. I agree with you. But later, they were known.
Later known.
They were known.
By him?
Not by him. He's not an investigating officer. By the investigating team.
No, ma'am. The investigation team and the investigation officer, being you, jumped to the conclusion that the 2 policemen in uniform must have been Khoza and Sabandi. You jumped to that conclusion without any proof.
I didn't jump into conclusions, sir. That's according to the investigation and according to their statements and according to Mr. Fritz's statement. Fritz was working at Brakpan. He knows all the officers. There were no other officer that was there in that scene, except for the 3 of them.
Ma'am, you've already conceded that applicant number 2 and his version that he was not dressed in uniform, that can be true. You've already conceded
yes,
that.
I agree with you. So as much as you're saying that, that's why I explained to you and said, according to Van der Merwe, even the bulletproof can prove as part of a uniform. So we cannot say the bulletproof is not part of uniform. If one say police was wearing uniform because referring to the bulletproof or a cap or anything that belongs to SAPS, that is uniform, sir.
Ma'am, is there any indication that applicant number 2 was wearing a bulletproof?
According to his statement, sir.
Ma'am, as far as the assault is concerned, Mr. Van der Merwe claimed that the assault was perpetrated by Leandre Pretorius and 2 African SAPS members wearing full police uniforms. Is that correct?
That's according to his statement, sir, yes.
Is that correct?
I'm with you, sir. I'm just looking for Mr. Van der Merwe's statement.
Thank you.
Yes, but I am saying yes, if you are reading from his statement.
Are you?
I'm with you, sir, yes.
Thank you.
Yes.
Ma'am, so therefore only wearing a bulletproof is not regarded as a uniform, a full uniform, is that right?
It's not full uniform bulletproof only, but it's uniform, sir.
Ma'am, I put it to you that therefore the assumption cannot be made that applicant number 2 was the person referred to by Mr. Van der Merwe that was present on the scene.
I don't agree with you, sir. Your applicant was there at the scene on the day in question. He was also there in that scene on the day in question.
It's not disputed by applicant number 2 that he was there in question, ma'am. The situation is, what is disputed by applicant number 2 is his involvement in this whole incident and exactly what he did and at what time he arrived on the scene.
Sir, I think your facts are more based on the trial matter as to what time did he arrive on the scene, what role did he play on the scene. But the fact of the matter is, on the day of incident when Mbense was killed, applicant number 2 was also on that scene, and he disposed a statement, and there are supporting documents that proves that yes, indeed, he attended to that scene. So as a police officer, he's got an obligation to dispose a statement, to explain, to say what was his role on the day in question.
Ma'am, part of the grounds on which you are opposing the release, and remember, I'm referring only to applicant number 2 now.
Yes, sir.
Is part of the grounds that you're opposing the release of applicant number 2 on bail is the strength of the state's case.
That's correct, sir.
And I put it to you, ma'am, based on the fact that there's no indication and at no stage was it mentioned what applicant 2 exactly did and where he was involved in on the scene, that you cannot jump to the conclusion and say, based on the fact that he's a police official who has placed himself on the scene, that the state has got a strong case.
It's got a strong case, sir. Moreover, he's an official, say. We are talking about an SAPS official here. Who knows, who has been trained, who knows that if something goes wrong to the crime scene, in fact, even if nothing goes wrong on the crime scene, if it's a crime scene, he knows that there are stakeholders that are supposed, role players that are supposed to be called to that scene. One, like photographers, they cannot attend a scene without a photographer. So as an officer, he cannot rely to other people and say they were supposed to call so and so. Meantime, he will leave the scene that belongs to his area. He left his house going there when he was already off duty, say. So he must take all the responsibility on that matter.
Ma'am, there were other senior police officials who was present there. He only attended to give assistance and to make sure that the role players who were present and on the scene, that they were not exposed to danger, and because the information that was available is that this crime that they were attending to was committed by heavily armed perpetrators.
Say yes, I agree with you. That was the information that they were given, that the crime had been committed by heavily armed perpetrators. As an officer, when you approach that scene, you must wear your bulletproof. Hence, the bulletproof, he was wearing a bulletproof for that sake. And 2, if you say there were other senior officers who were there, there was no senior SAPS senior officer that was there. Say each and every crime scene belongs to SAPS. It doesn't belong to EMPD. It doesn't belong to any metropolitan department. It belongs to SAPS. An SAPS member who is at the crime scene takes responsibility of the crime scene. There is no way that he will refer to the senior officers that were coming from EMPD or any other organization. He must mention a senior officer from SAPS who was there, because it's like there were senior officers from SAPS who were there that he is not mentioning.
Ma'am, the situation is, once applicant number 2 saw that the matter was under control, that the people who were involved with this matter had everything under control and that they were not exposed to any harm or danger, he withdrew from the matter because he was not really involved with this matter at all.
Sir,
And he was already off duty.
sir, I like your last comment to say he was already off duty. he left his house when he was already off duty because he was on duty very early in the morning. But upon seeing that message that was on the WhatsApp group, he chose to attend. SAPS doesn't run out of members to attend the crime scenes when it's necessary. If you are off duty, you are off duty. Somebody on duty must go and attend to that scene. So if you say, because he was already off duty, he left the scene because now everything was taken care of, by who? And SAPS members doesn't leave the crime scene, you hand over the scene. When he left the scene, to who did he hand over that scene to?
Ma'am, he was never in control of the scene. He only arrived there after they received the call to give assistance, and when he saw that the matter was under control, he left the scene.
Sir, any crime scene in South Africa belongs to SAPS. It doesn't matter where in South Africa. It belongs to South African Police Services. So when an SAPS member reached a crime scene, even if he was passing there, and then he realized that this is a crime scene, he cannot just leave. He must dispose a statement, hand over the scene to somebody else who must take over that scene. So for him to say, after realizing that everything was in order, then he left. That's impossible. It doesn't happen that way. He was supposed to hand over to crime office members because it was a crime scene. So there is no crime office member or investigating officer in that matter who was there to take over from him as a uniform member who was there. Mr. Fritz, Constable Fritz, who was there by then, who was still a constable, was a reservist. A reservist will never be in charge of a scene. And what is it? A permanent member must be the one that must take. It doesn't matter even Mr. Fritz was higher in the rank than the members that were there. When the members come to that scene and then there's a reservist, the permanent member must take over. So his responsibility was to hand over. So to who did he hand over that scene? Because he left because everything was in order.
Ma'am, he never took control over the scene. He merely attended the scene. He was not in control of the scene. He was not in charge of the scene. There were other police officials that was in charge of the scene.
Say, for his intention to leave the house and drive a state car and goes to Brakpan to attend to that scene that was circulating on WhatsApp group, he must account. Because he's using state resources to go there. He must account as to what was the reason he went there. He cannot go there, then when he finds that everything is under control, then he just leave. Even if there was a senior officer there, his statement was going to say, I left the scene because I handed the scene, or the scene was under control of Colonel so-and-so or Captain so-and-so. But without an SAPS member, he cannot leave that scene just because and leaving it to the metropolis officers. No, it doesn't work that way, sir, and he knows it very well.
Ma'am, he did not leave it only to the Metro Police. There were other police members that were present there and was involved with the matter. And due to the fact that there was no further need for him, he left the scene because there was no reason for him to spend any further time on the scene.
Sir, I don't agree with your statement. I don't.
Ma'am, you know, what is a crucial discrepancy as far as your investigation in this matter is concerned is when you realized that there was this allegation being made of two unknown police officials dressed in uniform. You never conducted the ID parade for Mr. Van der Merwe to try and identify these people. Why not?
No, the ID parade was never conducted, sir.
Yes, why not?
I don't see a necessity of it by then, sir.
Oh, man.
I didn't see the necessity of it during that period.
Is to erase this question mark of the unknown police officials. If you've done an ID parade at the time when Mr. Van der Merwe was still alive, you could have erased this question as far as the unknown factor of these two police officials.
So remember that Mr. Van der Merwe, as you say, he said unknown.
Yes.
So I had to investigate and find those officers to be known.
Ma'am.
Then when they were later known, sir, they were identified. We don't need an ID parade in SAPS to identify members who are on the scene performing their duties. We can do an ID parade members who were there to commit crime because they wouldn't do everything they are supposed to do according to books. So we got everything we were looking for at Brakpan SAPS, whereby including the registers of the car they were driving, their SAP 15, which is the register that they write their names when they book on duty, including their commander's statement, who mentioned as to they were on duty, they knock off at what time on the day in question, sir.
Ma'am, the 827 statement, sorry, my learned colleague was...
Counsel for
The
the state.
Thank you, Worship. My IO Worship has already taken part of my objection, but I was just going to bring Worship to the attention of my learned friend that when he mentions that there were unknown subs members, it is not so according to the statement of Marias. Paragraph 14 is clear, Worship. I can read that paragraph. That I then went into the room where the suspect had been taken by the Brakpan subs members. I found Viandre's body chopping the suspect with a plastic bag, with the two Brakpan subs members assisting him, not just unknown members, Brakpan subs members. May my friend also put that when addressing the witness.
Yeah, but the names are not mentioned.
And now, Your Worship, now it is now specific that it's not police members from from somewhere.
Mr. Van Heerden.
Thank you, Your Worship. It's my respectful submission that my learned colleague is trying to lead evidence from the bar. And if he wants me to cross-examine him, I will do so, but I don't think he's allowed to give evidence from the bar. Your Worship, it's my respectful submission that the situation is, as far as this question is concerned, it is relevant and it needs to be answered by this witness.
Yes, it is relevant. The witness has answered.
Thank you, Your Worship.
Further question.
Ma'am, I put it to you that as far as the identity by Mr. Van der Merwe of the two police officials in police uniform, his evidence is that he heard from somebody that they were from the Brakpan police station. That is his evidence in his affidavit.
Can you refer me to that paragraph, sir?
Paragraph 10 of his typed statement, ma'am. JVR 5.
Attached on which exhibit, Mr.
That
Van
will be
Heerden?
attached to applicant number 1 statement, Your Worship. That's the supplementary affidavit. That's the statement that you took, ma'am.
Sir, I'm reading the statement. You are saying...
No, it's not my statement, ma'am. Sorry for interrupting you. It's not my statement.
I'm reading Maria's statement.
Yes.
According to the paragraph you're referring me to, paragraph number 10, if I understood you well, you said Maria's heard from somebody else, but I don't see a line here that is saying Maria's heard from somebody else that these were SAPS members from Brakpan. I might be reading a wrong paragraph, maybe.
Have a look on page 3 of the 12 statements.
Page 3 of?
The statement. I presume this is the Madlanga Commission statement, ma'am. That was handed in at the Madlanga Commission. paragraph 10, page 3 of that statement of 12 pages. That's a typed statement from him.
So you had referred me to a statement that was taken by me.
Ma'am.
It's the one that I'm having here.
Have a look at the Madlanga statement.
I don't have.
JM1. Your Worship, I believe it's in applicant number 5's statement, the portion where the Madlanga Commission's statement is attached to. If we can just hand that to the witness, please.
I don't have.
Did you say JM1?
JM1, that will be the type statement of Mr. Marius van der Merwe, and it's on page 3 thereof, Your Worship, paragraph 10.
Is the one which starts with as I enter the house?
Your Worship, unfortunately, only yeah, that is that one, Your Worship. That paragraph, as I entered the house from the kitchen door, I found Fritz Viandre Pretorius. That's that portion, yes, Your Worship. And the relevant portion that I want the witness to comment on, present were also 2 unknown SAPS officers in police uniform who were said to be from the Brakpan police station.
Okay, so I see that.
And,
Yes.
and an unknown black male.
Who was the suspect? Yes, that's correct, yes, Your Worship. That's the full paragraph there. So, ma'am, I put it to you that Mr. van der Merwe didn't know, or could not identify these people as being from the Brakpan police station. He based that on evidence that he heard from somebody else.
Say,
But can I update you to this? Worship, it's not helping to read one portion and not look at the statement as a whole. Management is quoting from 10. 14 of the same statement is mentioning now that they are from Brakpan. In the same statement.
Maybe he has opted to start with paragraph 10.
But,
Let's hope he'll go to 14.
oh, thank you.
The question is allowed.
Thank you, Worship. Ma'am, and from there, from this hearsay portion of information that Van der Merwe obtained, from there he jumped to the conclusion that they were from the Brakpan police station without any basis or any grounds for him to come to that conclusion.
say, no, I don't agree with you to say he jumped into conclusion that they were from Brakpan police station. I don't agree to you concerning that. Mr. Van der Merwe did mention that he didn't know them. Hence, when he was giving his statement, he didn't mention their names because he didn't know them. But because they came with Alexandra Fritz that he knew, Alexandra Fritz is the one who explained to say, I am still waiting for 2 members that are coming to join us for this operation, which was your client and the deceased, of which they did came. So for you to say he heard from somebody else, you are correct. He heard from Alexandra Fritz, who was working with the members.
Ma'am, you're contradicting yourself. You say that, that they arrived with Fritz. Then you say that Fritz was said to Van der Merwe he was still waiting for members to arrive.
You are right, say. I'm not contradicting myself. I am referring to Mr. Marias's statement. If I'm answering your question of saying Mr. Marias had the information from somebody else to say these members were from Brakpan, he had that from Fritz, who was working with them. He didn't hear it from somebody else.
Ma'am, where do you get that from?
Just wait, sir. I will read a paragraph. Let me just go to the statement that was taken by myself.
Do you still have questions, Mr. Van Heerden?
I was waiting for an answer, but if you're not waiting for an answer, then I can carry on. Ma'am, I want you to refer you to the witness statement of Mr. Marius van der Merwe, A7. And if you have a look at paragraph 3 thereof, and I'm going to read this portion to you. Zander Fritz, who also arrived with 2 African males that were in full uniform, not bulletproof only, in full uniform in a marked SAPS BMW, marked Brakpan with call sign BP32. Is that correct?
You're still reading, say yes. I'm trying to go with you.
Okay. Zander,
You said paragraph 3.
paragraph 3.
Okay.
Zander was wearing police trousers, police boots, and had a black or blue t-shirt with black bulletproof on top. Is that right?
So you mean is this right what you're reading, or you are asking me if it's right what is being said here?
Ma'am, and at that stage he was still waiting for 2 police officials to arrive.
Yes, what you're reading here.
Yes, that's correct. So it is clear that there were 2 police officials dressed in full uniform, and later two other police officials arrived. Is that right?
Say there were no other police officers that came from Brakpan police station to attend to that scene on the day in question.
No, ma'am, you've already conceded that the vehicle in which applicant number 2 was driving also arrived on the scene. You've already conceded that, ma'am. So at the very least, there must be 2 more people that must be added to your list of people who are present on the scene.
Not from Brakpan police station, say no.
Well,
Because according to their records and books, none of the members attended to that scene on the day in question.
ma'am, you know, the problem I think that you have as far as this matter is concerned, you're not prepared to concede that there were many more people present on the scene than what you've limited to your 11 names that you've listed in your opposing affidavit.
So I do agree with you that it's possible there were more than 11.
It's not possible, ma'am. It's a fact, the fact that there were more than 11.
Okay, sir.
If you have a look at the evidence that was adduced by Mr. Marius van der Merwe at the Mhlanga Commission on the 14th of November 2025, date 33, on page 142 of the 190 pages. And I'm going to read that portion for you from line 8. The PIN location provided by Kobus Jansen van Rensburg took me to Sally's village in Brakpan, where some SAPS, EMPD and private security members waited for us. That's one part. Upon my arrival, I found Jaco Hannekom, a SAPS informer of ill repute, Beandre Pretorius, a person that frequently presents himself as a SAPS member, Constable Johan Marie Extien from Northeastern Flying Squad, Constable Zander Fritz, Reservist Constable from SAPS Brakpan, with 2 SAPS Brakpan officers unknown to me. Present were also EMPD officers, Kasia Stolz, Adrian Mackenzie, Etienne van der Walt from Titan Security, and other members whom I cannot identify. So it's clear that because you limited your list of names to these people here, from the evidence of Marius van der Merwe, it's clear that there were several other people, members of the police, who were there on the scene.
I agree with you, sir.
And that's why I say to you, ma'am, you cannot limit it that to applicant number 2.
Sir, applicant number 2 was there as well.
Yes.
As an official of SAPS who is responsible at the crime scenes, he was supposed to mention his role. Moreover, say you are the one who mentioned that your client was off duty and he attended the scene when he was off duty, while there are members who were on duty who were supposed to attend to that scene, but the station was never aware of such a crime scene, which is Brakpan SAPS.
Ma'am, the situation is, and I told you we're going to get back to this aspect of this legal principle of common purpose. As far as this incident is concerned, will you agree with me that there was an initial meeting on the scene before the members went onto the property, where certain things were discussed between the people who were present there, whoever they may have been?
Yes, there was a meeting.
Then there was a further discussion after the deceased died on the scene, that there was a further discussion. That was a further meeting, is that right?
That's right, sir.
Then there was a meeting that took place at the, or close to Carnival Mall, where there was a further discussion.
No, sir, I thought you were referring to that meeting. Now you are referring to the third meeting. That means I didn't get, I don't know about the second meeting you're referring to, but the Carnival Mall, yes.
Don't you know about the second meeting where it was discussed as to what needs to be done with the deceased body?
Or in their house, sir,
Yes,
yes. Okay, all
That's
right.
the second meeting.
All right, sir,
Okay.
that's fine. Yes.
Then
I'm
there's a
with you
third
now.
meeting of the Carnival, close to Carnival City.
Okay, I know about it, yes, sir.
Yes, and then there's a fourth meeting at Rose Lee.
Yes, sir.
Ma'am, there's no indication whatsoever that applicant number 2 were present at any of those meetings or discussions that took place at the time.
There is, sir. Moreover, let's go to the meeting of Carnival City.
Yes, let's go to the meeting of Carnival City, ma'am.
Yes, sir.
Where is the name of Sebandi mentioned as far as that meeting is concerned?
I've not yet done with my response, sir. Okay, sir. Paragraph number 18
Yes.
of Mr. Marias's statement, the typed, it's JRV, I think 5. Let me see, the typed one. Yes, CJVR 5. And then paragraph number 18. Let's go to line number 5 of paragraph 18. I then drove back and met with the whole team that was in the house waiting by the road next to Carnival City. That's the meeting at Carnival City.
Ma'am,
According to, say, I'm not yet
please
done
continue.
with my response.
Please carry on.
According to Marius, everyone who was in the house was in this meeting. Your client as well, according to Marius, and according to himself, he was in that house. Then he was in this meeting. That's according to this statement from Marius van der Merwe.
Ma'am, the crucial point here is, and the definition that is given by Marius van der Merwe as to the people who were there, is the people that was in the house, not on the premises, in the house. Applicant number 2 denies and disputes, and that is clearly stated in his statement and the other statements that was made by, the warning statement that was made by Zander Fritz, that he was not inside the house.
Sir, the statement of Marius doesn't say that the people who were in the bedroom. It says, I then drove back and met with the whole team that was in the house waiting. So, say, if you say, Marius is saying here, is referring to people who were inside the house, not from the statement that I took, sir.
Ma'am, that is
Maybe
what
from another statement.
that is what you wrote here. The people who were in the house, not people on the premises, people in the house. You wrote that. You the author of it. You, if you took the statement down from Marius van der Merwe, and that's the way how you took the statement down.
He was not referring to inside the house.
Ma'am, that's semantics that you're not going to get away with, and because it's clear that was people in the house, and
No, sir.
yes.
No.
Ma'am, and then as far as the meeting, and that is on that same statement, at paragraph 19, that's the Rose Tooley meeting. There's also no indication that applicant number 2 was present at that meeting.
I agree with you on that one, sir.
Yes. So, ma'am, as far as the common purpose is concerned, applicant number 2 denies that he was involved in any of the discussions that took place as far as the incident is concerned, how it was going to be conducted, what was going to happen, and what they're going to do with the deceased body, and how they're going to conceal this, and what will happen if they should talk out. He was not involved in any of those discussions.
Sir, for the mere fact that your client is an SAPS member, he failed to report. Even if, let's say, he didn't participate in any of these things that went wrong there, for the mere fact that he is an SAPS member, he failed to report to the seniors to say, this is the crime scene. Even if he doesn't report, he failed to call the relevant the role players to come and attend to that crime scene. Then he leaves after handing over. But instead, he doesn't report to it to anywhere. When he is approached, he say, I choose to remain silent. He doesn't explain as to what transpired on the day.
Ma'am, the situation is, and this is what you must understand, and it's clear that you're trying to give a different definition of what and how common purpose is formed. And by stowing obligations on a police official that is contrary to the requirements for common purpose.
I'm
common
not trying that.
No, please. I allow you to answer. Please allow me to finish my question as well. Then, that there's no indication that applicant number 2 was involved in any negotiations and to form a common purpose. And it is not about the duties of a police official or the neglect of him or performing his duties as a police official. The question here is about the forming of a common purpose.
So for the forming of a common purpose, the prosecution who drafted the charge sheet will expand to that. I investigated a case docket of murder and defeating the ends of justice, sir.
Ma'am, the situation is that from the DNA evidence that was obtained, there were samples taken from applicant number 2 as well. Is that right?
That's correct, sir.
And he was excluded as leaving any DNA material behind on the scene at all.
I don't agree with you to that. If you say, the way you put your statement, sir, I don't agree to what you're saying.
Ma'am, is there any positive finding that from the laboratory that the DNA of applicant number 2 was found on the scene?
Sir, you must understand as to what was the sample, that they are samples to what were they being compared to. So if your statement is saying no DNA was found in that crime scene at all that belongs to your client, that DNA was never tested to the whole scene. It was only tested to one thing that was in that scene.
Ma'am, if there was DNA material found that was going to link applicant number 2 to the scene, I presume that you as a conscientious investigation officer will submit that and get the results from that to link applicant number 2 to the scene. But there's no such evidence, ma'am.
Unfortunately, this crime scene was attended by SAPS. It came back to IPH after weeks of the incident. Hence, the scene is like this.
Ma'am, you obtained this statement A27 from applicant number 2 when?
Can you allow me to go back to it?
Yes, please do.
Okay, so the first statement was obtained on the 16th of May 2023.
2023.
Yes, sir.
Since 2023, applicant number 2 was aware of the fact that you knew that he was involved or not involved, but that he was present at the scene where this incident took place. Is that right?
That's correct, sir.
Now, from that date, ma'am, is there any indication that applicant number 2 at any stage interfered with any of the possible state witnesses?
Nothing that I'm aware of, sir.
Is there any indication that applicant number 2 at any stage tried to destroy or interfere with any evidence material that was obtained?
No, sir.
If you wanted to do so, ma'am, you had more than enough time. Do you agree with me?
I do agree with you, sir.
Ma'am, as far as the situation is concerned, and the aspect, and that is one of the big concerns from the state, is that the applicant number 2 is a flight risk and that he's not going to stand his trial. He had more than enough time to abscond and to evade you as far as the prosecution is concerned. Do you agree with that?
Sir, in my statement, I never mentioned to say applicant number 2 is a flight risk. Hence, I even explained to this court to say all of them, from applicant number 1 to 6, all of them, they have been cooperating whenever we need something from them. There is no day whereby they said, we don't want to come, or whatever remarks. So that one I did mention.
Yes, ma'am, and I thank you for that. But the problem is that as far as the objection by the state is concerned, as far as the release of all the accused is concerned, is that they are a flight risk and that they're not going to stand their trial.
Sir, but if you go to my statement, the bail statement that I made, if you go to my bail statement, say on I will say paragraph number 15, all of it from 15, where I said grounds for opposing bail in terms of section 60, that is when you can understand as to where is it coming from.
Yes, ma'am. That they will await their trial. That paragraph 50.2 of your statement, you say that there's a likelihood that they will evade their trial. There exists a substantial risk that the accused, and that includes applicant number 2, may abscond if released on bail. It includes applicant number 2. That's your statement.
That's my statement, sir.
Yes.
That's correct, yes. It's because of the seriousness of this offense. Remember, during the investigation, they never thought that it was going to be this serious, because they had thought that this case was not going to end anyway, sir. So now, due to the investigation that has been conducted, now they are here. They are realizing the seriousness of this matter. Now, it can be possible that if released, they cannot come back to attend trials.
Ma'am, let me rest you assure that as far as applicant number 2 is concerned, he always considered this as a very serious matter.
Okay, sir.
Yes.
Thank you for that.
Ma'am, I put it to you that there's no ground for you to believe that applicant number 2 will not stand his trial.
Sir, like I've mentioned my reasons here. So I'll be going back explaining the same thing that I've just explained to you now, sir.
Ma'am, applicant number 2 even made contact with you to inform you of his whereabouts and that you could contact him if you need to find him. Is that correct?
Made contact of his whereabouts to me.
Yes,
Sir, I'm the one who made contact with him.
yes.
Yes,
And-
sir.
And he responded to that to say to you that if you can't find him, you can contact him. And that was a WhatsApp that was sent from my office to you.
Sir, like I'm saying to you, none of the applicants that are here have ever not responded when needed. So what you are mentioning now, I cannot deny it. Even though I don't remember that WhatsApp, if it was sent, it's possible it was sent, because they had never said, we won't come to you if you need us.
Ma'am, as far as, and you know, it's not really applicable to applicant number 2, but you make a sweeping statement in your opposing affidavit, and that is in the just above paragraph 15.4, This is according to Etienne, who states that Mkhwanazi was supervising them when they were giving warning statements to IPID officials. He suggested how the contents of their respective statements should look like. This coaching is visible in the Precious Stone case and in the warning statements that they gave in this current case. Ma'am, where do you find the similarity as far as applicant number 2's statement is concerned to the other suspects or applicants? There is none.
Sir, as you were reading my point there, it's stating straight very well. It doesn't talk about your client, sir.
Ma'am, unfortunately, by opposing and making a statement in opposition of the application that includes applicant number 2, it also includes and has an impact and a bearing on applicant number 2's bail application.
Sir, that cannot rule out that they were having meetings here and there concerning the matter, because they were all aware from 2022 about this matter. During the day it happened, they knew that if somebody died, a case will come out. And then the case was investigated up until now, when they were arrested, sir. So it's possible that in between there were meetings that were being held, even not in person, whatever way, to discuss about this matter.
It's also possible that they can be completely innocent.
Sir, the case, the state has got a very strong case. I don't agree with you, sir.
I put it to you that there's no basis for you to oppose the application for applicant number 2 to be released on bail?
There is basis. Here we are talking about other co-accused, or what they were then suspects when they passed on. That died. None of them died due to sickness. They all died due to gunshot wounds, all of them. And the concern in all that say, it concerns because they all relate to this matter.
Ma'am?
And those cases are not yet solved.
Ma'am, as far as the tragic passing on of some of the people who were mentioned in this matter, there's absolutely no basis for you to link any of those people's deaths to applicant number 2.
You are correct, sir. Hence, those cases are not yet solved. They are still under investigation.
Yes. Applicant number 2 is not the suspect in any of those matters, ma'am.
Sir, my only concern is all those people who died. They died after this came out, and they were threats that they were saying, anyone who will talk about this will die. Then now, sir, after that, people started falling off, dying. Now, you cannot rule out to say they died in relation to this matter. If you were saying, sir, people were arrested on those matters, they were killed by so and so wherever they were killed, then it's something else. But up to now, it's not yet solved. All those matters are not yet solved, sir. So we cannot say, no, it's not relating to this matter.
Ma'am, clearly you cannot include the death of Viandre Pretorius under this argument that you've just made.
Hence, I said they were killed. Viandre Pretorius killed himself, but it doesn't rule out to say he killed himself because of this matter. It doesn't rule that out.
Does not involve any of the applicants before court to be involved in that, ma'am?
No, he killed himself, sir.
Yes. Ma'am, as far as Khoza is concerned, the late Mr. Khoza is concerned, there's also no indication that any of the applicants were involved in that death of the late Mr. Khoza.
Sir, those cases are still under investigation. I don't know if there are statements that are mentioning that, what you are telling here in court now to say. The clients are saying they were not involved in those matters. I'm not sure of that. I don't have a copy of such statements.
Yes, ma'am, but you as an investigation officer has got access to those dockets. You could have made inquiry about that. And I would have expected you as a conscientious investigation officer to established from the IOs in those matters as to whether any of the suspects before court are linked to those deaths?
Say, if a matter is still under investigation, you cannot, that means the investigation is still ongoing. You cannot come and say, this person is now linked to that matter because it's not here on the court roll. So none of the investigating officer can mention that. The cases are still under investigation, we'll take it as like that.
And ma'am, this can happen like in this matter where this incident happened in 2022, and only after there was mention being made as far as the delay in this matter in the Mdlanga Commission is concerned, that this matter started to get momentum. It can take years before we get to the bottom of those deaths of the people that you're referring to.
Sir, I don't agree with you when you say the case took momentum after the Mdlanga Commission. No. The case was already taking momentum, sir. If you go and relate to this statement, Mdlanga Commission, Marius testified in November. Then you can, because you do have copies of the docket, you can count as to how many statements were taken after November when the Mdlanga Commission has called to this matter. So this matter is not that it came into momentum after Mdlanga Commission. It was already on.
Ma'am, if you have a look at the evidence of Commissioner Revo Spies at the Mdlanga Commission, he clearly criticized the delay in the investigation of this matter.
Sir, I don't want to get to that, but for your own clarity so that you don't mention it again. Mr. Commissioner Spies, IP doesn't report to him. He didn't have any knowledge as to how far the matter was. And IPID cannot go to report how far is the investigation on this matter while IPID was investigating the Ekurhuleni Metropolitan officers in that matter. So hence he went to Mdlanga clueless, thinking that nothing was happening. IPID was not reporting to them. Only when the investigation was finalized, we were going to give him the recommendation to say, charge your members. That's all that he was going to get, not any feedback from IPID relating. None of the feedback we give to them that we investigate their members. We don't report to them.
I put it to you that there's no basis for you to oppose the release of applicant number 2 on bail.
The reasons are stated in my statement, sir.
Thank you, Worship. I've got no further questions to this witness.
Right, 5 minutes past 1, 13:05. This is the opportune time to adjourn. For this matter, the court shall adjourn until 2:30. I've got the role to deal with from 2 o'clock to 25 past 2. Court adjourns.
Thank you, Worship. Ik ben ook heel goed oorgemosterd om vrae te vra, Christo.
Angeke size siqede you must get it back because I will end up with my documents. You will borrow it to me again when somebody refers to it. I'm not just give you the document one. I will get it from you whenever I need it.
Just for
and we observed the scene. Have you conveyed the message to applicant number 2 about the whereabouts of Mr. Van Buren Sr.?
I have indeed done so, yes, sir.
Thank you.
As it is.
Thank you. Counsel for applicant number 1, Mr. Van Veenkar. You reserved a certain question last time.
That is
I
correct, Your
think this
Worship.
is the opportune time to proceed with cross-examination or
Thank
further
you.
cross-examination,
Thank you, Your Worship.
as I have already made a ruling this morning.
Thank you, Your Worship.
Are you ready to proceed?
Yes, I am.
Where's Mama Suku? Wow. Who's fishing and so
I'm here, Your Worship.
Ma'am, are you aware that you are still under oath?
Yes, I am, Your Worship.
You are warned to talk the truth.
Thanks, Your Worship.
Thank you, Counsel.
Thank you, Your Worship. Ma'am, we've established on the previous occasion that you did indeed testify during the Madlanga Commission. If I can remember correctly, it was on the 12th and the 13th of February this year.
I can't remember the date, but yes, I did.
Testified.
Yes.
Now, I want to put it to you and just indicate whether or not you can remember your testimony pertaining to Mr. Marius van der Merwe. And if you cannot remember it, or if you are going to dispute what I'm going to put to you, we do have the video clip pertaining to that we can play in court so that you can verify that that is indeed so. But you testified pertaining to Mr. Marius van der Merwe that the Director of Public Prosecutions will never use Mr. Marius van der Merwe as a so-called 204 witness because he was not honest. He was not an honest witness, and therefore he will always be an accused. He will be perceived to be an accused. He will never be a witness. Can you remember that you testified pertaining to that?
I remember say, but I'm not sure about the exact words, but yes.
So that
Yes.
that was your contention when you testified during the Madlanga
That was
Commission.
correct, sir, yes.
Thank you. Yeah, and one further aspect, you also indicated that the Director of Public Prosecution at that stage indicated that they cannot proceed with the actual charges at that stage because they were sitting with a so-called single witness who is an accused, and it is going to be difficult to prove the case on his evidence.
Say, your
Are you
question,
referring to the evidence of Marius van der Merwe?
Marius van der Merwe, yes.
say, as you are referring to the Madlanga Commission of Inquiry questions and testimony that I gave there, when I gave testimony there, it was not, the case was not yet decided by the DPP. It was still under investigation. And regarding that, there was nothing from the DPP side that was saying Marius is our witness. What I was investigating Marius as a suspect, and I still emphasize that myself to the commission to say, according to me, Marius was the suspect because he was involved in a commission of a crime.
Yes.
But then the DPP made their own decision according to them to see that Marius is deemed fit to be the witness.
Right, but the fact of the matter is there was at no stage was any statement obtained of Mr. Marius van der Merwe in terms of the provisions of Section 204 of the Criminal Procedure.
I didn't have that statement, sir.
Sorry?
No, there was no such statement, sir.
Yes. Right, ma'am. Then one further aspect, and that's the last aspect that I want to deal with. If I understand your evidence correctly, you want to put before the court that the deceased must have been assaulted, tortured over a period of time.
No, I'm not putting that to the court because I was not there, say, but I've got the postmortem report that is saying he died due to the blunt force trauma to the head.
All right, let's.
So it goes in line with what Marius gave according to his statement.
Right, so let's maybe place that before the court so that the court also in the interest of justice knows what the cause of death is. According to the post-mortem report, the external appearances of the body and the conditions of the limbs, I'm just going to put that to you, indicates black male, submerged in water for a period of plus minus 12 to 24 hours. Then it says multiple contusions on the forehead. It says a 1 centimeter by 1.5 centimeter left upper frontal area, 1 centimeter by 0.5 centimeter lineal horizontal left and right side 2 centimeter above the eyebrow, right parental lobe and lateral of the right eye open 0.5 by 0.5 centimeters. Left ear was eaten by crabs, swollen face and left side of lower lip. No other obvious external injuries noted. And then, as you've indicated, the cause of death is being indicated as head injury due to blunt trauma. Do you confirm that, ma'am?
Yes, I do, sir.
All right. So, according to the post-mortem report, there were a few injuries on the head, external injuries on the head of the deceased. He had bleeding of the brain, but pertaining to the rest of his body, the chest area, the back area, the limbs, there were no injuries whatsoever. Do you confirm that?
I don't confirm that, sir. That one, the pathologist will come and testify on that because there are scientific words here. So I don't want to confirm something that I don't know. This document was not drafted by myself.
I want to put it to you, ma'am, that the injuries that I've read out indicates the external appearances on the body and the condition of the limbs. Except for these injuries that I've indicated to you, that there are, and I want to put it to you because you know that the defense has obtained a copy of the docket, and according to the post-mortem report, there are no other injuries. And I want to put it to you further, my learned colleagues for the state seated in court, if I put anything to you which is not correct, they will object to any questions which I put to you which is not correct. According to the post-mortem report, there are no further injuries on the body of the deceased.
Sir, I don't understand when you say there are no further injuries. If you were saying there were no injuries at all to the deceased, it doesn't matter which part of the body. Hence, the postmortem is saying blunt force head injury due to blunt trauma.
Yes,
that shows that there was an injury that was caused by a blunt force instrument or whatever that caused that injury. So, if you say there were no further injuries, that means there were some injuries. Then there are no further injuries.
Ma'am, it seems as if you really do not understand the question or you don't want to answer the questions. It's a simple question. According to the post-mortem report, all the injuries were on the head of the deceased. There were no injuries on any part of the deceased body. That is the crux of the question. And I want to put it to you, that is a fact in accordance with the post-mortem report.
So which page were you reading from a postmortem?
Do you have
I do have a copy. I'm not sure if I've got all the pages.
Look at Roman paragraph number 4. Page number 3. Do you see that?
Yes, I'm looking there.
Right. So you can then also verify for yourself that all the injuries that's noted there is on the head of the deceased.
Sir, I don't want to agree with you and say the injuries noted here, it's only to the head of the deceased. When the doctor comes here and then he mentioned something else. This is not my document.
Yes.
But what I can tell you is they were injuries, and those injuries resulted to him dying.
Yes, ma'am, and I want to put it to you once again, and I'm not going to argue with you. All the injuries is to the head. Of course, if you look at the chest, paragraph number 3, everything is normal. Abdomen, everything is normal. Spine, clinically intact. So the only injuries, according to the post-mortem report, is on the face and the head of the deceased.
Sir, you should have read everything. The chest is saying pleura and lungs, extensive petechial bleedings on both lungs. You should have read everything.
Ma'am, I'm talking about the external injuries of the body of the deceased. The only external injuries that is visible is on the head of the deceased.
Sir, because I didn't do that postmortem, I want to respond to that. The pathologist will come and respond to those questions. This is not my document.
Thank you, ma'am, because I've indicated that my learned colleagues for the state will object if I put anything to you which is not correct. Thank you, Bishop. I do not have any further questions.
Thank you. Ms. Kiwi, for applicants number 3 and 4,
Thank you,
any
Worship.
cross-examination?
Your Worship, I do confirm that I do in fact have cross-examination. If the court may just indulge me for a minute. Thank you, Your Worship.
Thank you.
Good afternoon, ma'am.
Afternoon, ma'am.
Before I proceed with cross-examination, I just want to ensure that you have the relevant documentation before you as a means to avoid being interrupted by looking for certain documentation.
Okay.
On one of the previous occasions, it was, or rather documentation was handed in support of applicant number 1 regarding a supplementary affidavit. Reference was made to CJVR4 and CJVR5. I don't know if you have that in your possession. If not, I do have copies.
No, I do have.
And then can you just confirm as well that you are in possession of JM1? That is the statement that was subsequently attached to the bail proceedings of applicant number 5.
No, sir, no, ma'am. I'm sorry. No, ma'am, I don't have that document.
Your Worship, if I may so be permitted, I did make a copy. May I be at liberty to provide the investigating officer with a copy of JM1 together with a copy of the bail affidavit pertaining to applicant number 3, which was marked Exhibit C, and then applicant number 4, which was marked Exhibit D, Your Worship.
Yes.
As it pleases the court, Your Worship, I am indebted. Okay, so to confirm, ma'am, you have CJVR4,
Yes.
CJVR5, JM1, as well as the 2 affidavits deposed to by applicant number 3 and 4, marked exhibits C and D in your possession. Is that
That's correct, yes.
Thank you. Now, ma'am, I'm going to commence cross-examination. I'm going to attempt to do it in the most chronological way that I can, and with reference to first dealing with the merits of the matter. Now, during the examination in chief by my learned colleague for the state, you had attested to the fact that the warning statements that were initially deposed to by applicants 3 and 4, when compared to their bail affidavits before this honourable court, differentiated insofar as the fact that there was no reference to other members being present when they had arrived. Do you remember saying that?
Yes, I do remember, but their statements, they do have to say there were other people there. Yes, they do mention people.
Okay, so with reference to that aspect in your testimony, you would concede to the fact that with reference to applicants 3 and 4, in both their warning statements and their affidavits in support of their bail applications, they had in fact made reference to the fact that when they arrived, there were other members on the scene. Is that correct?
That's correct, yes.
Thank you. Now, you further indicated during the examination in chief that when the submission or the contention was that maybe other applicants had not made reference to it, you indicated that if there were other members on the scene, why was reference never made to these members, the other officials that were on the scene at the time? Do you recall saying that?
Yes, I do.
Now, ma'am, if I can please refer you to the affidavit of Marius van der Merwe, which has subsequently been marked as CJVR4. It's the handwritten statement that he had subsequently deposed to.
Yes, I'm there.
Now, if I read, I'm going to read the contents in and then I will subsequently ask the question. It indicates on Friday, or on Thursday, sorry, the 14th of the 4th, 2022, at approximately 9 o'clock in the evening, I received information about a possible recovery of hijacked stock in the Brakpan area. Upon arrival close to the address of the possible hijacked stock, upon arrival, I found Jean-Marie Eckerstein from Benoni Flying Squad, Viandre Pretorius, who introduced himself as a police member from Crime Intelligence, Yaku Hanukom, Kersha Stolz, EMPD, Mackenzie, EMPD member, along with other role players that I did not know. Can you see that, ma'am?
I can, yes.
Do you then confirm that on the basis of the statement that was deposed to by Marius van der Merwe himself, given that the intention was to use him at some point as a Section 204 witness, he indeed confirms that some of the members that were present at the crime scene, he was unaware as to their identity? Do you confirm?
Yes, I didn't know them.
Thank you. Now, if we go to the aspect of the count of, or rather count 1 being that of murder, okay, we are still making reference to the same statement, okay? If I make reference to paragraph 4, within the contents of that paragraph, Viandre Pretorius, or rather it's alluded to that Viandre, or let me rather read it in. I'm going to start, ma'am, it's line 1, 2, 3, 4, 5, 6, 7, the 8th line. I don't want to read the whole paragraph. Obviously, you do have it in front of you. Are you at the 8th line?
Yes, I am.
It indicates there, upon entering the premises, I found Viandre Pretorius talking to a police officer unknown to me. They proceeded to a room on the left side of the house with the suspect. Myself and the other EMPD and SAPS members proceeded to search the rest of the house for additional exhibits. After a few minutes, I went back to the room where Viandre and the suspect were. Do you confirm that that is what is noted on there?
Yes, I am.
Now, do you confirm, ma'am, that on the version of what is contained in this statement, at no stage was applicant 3 or 4 in the room where the unknown members, together with Viandre Pretorius, had taken the suspects? Do you agree with me?
Yes, on the lines that you read, yes.
Thank you. And you further agree with me that on Marius van der Merwe's own affidavit, he confirmed that at some point he had went back into the room where whatever was happening was happening. Is that correct?
Yes, yes, ma'am.
Thank you. Now, Marius, further in that same paragraph that I've just referenced, indicated, and I'm just going to simply ask you to confirm that it's conveyed in the statement, that himself, EMPD members and the SAPS were searching the premises. Do you confirm?
Yes, still on the lines that you read.
That's correct,
Yes.
And if we then make reference to paragraph 5, I'm just going to read same into the record. I find the suspect on his back with Viandre Pretorius on top of the suspect, assisted by 2 other members. I asked Viandre if I can ask the suspect a few questions. I asked the suspect, where is the stock of the hijacked truck? The suspect wiped away his tears and told me that he will talk to us and that there's 500,000 rand inside the house. I asked him for the location of the hijacked stock as I'm not interested in the money. At that moment, Viandre Pretorius and the other police officers started suffocating the suspect with a plastic bag. I exited the room and helped search the rest of the house. Do you confirm the contents of that paragraph?
Yes, I do.
And you will confirm that, yes, again, applicants 3 and 4 were not present at any point during this, be it, let's call it an interrogation or whatever one may deem it to be. Is that correct?
That's correct, yes.
Now, if I refer you, then, ma'am, to the statement, a further statement deposed to by Marius van der Merwe, the one that is labeled CJVR5. You can just confirm when you have it in front of you.
Yes, I'm there.
If if I refer you to paragraph, apologies, Your Worship, if the court may just indulge me. If I refer you to paragraph 8, Marius van der Merwe in the statement deposed to, I asked Quibus if he could confirm if it was that truck. He said yes. I proceeded through the kitchen and realized that there was commotion in that passage. I then saw an African male that was being grabbed by the waist of his pants by 2 SAPS members that were wearing uniform, and they were and they said, here was the suspect. Viandre told the suspect that he should know as to why we were there. The suspect had a confused look on his face. Viandre asked him to show us the stock hidden. That African male agreed that he was going to take us where the stock was. The suspect further explained that there was money inside the house and said we can talk, and the suspect was then pushed into the room. Do you confirm yet again that with reference to the attribution of the African males, in the event that it was indeed, be it, let's just call a spade, applicant 3 or applicant 4, Marius van der Merwe would have made reference or specific reference to a name? Do you agree?
I agree with you.
So yet again, we can confirm that on the basis of his second statement, applicants 3 and 4 were not present at the time that Viandre Pretorius, together with the SAPS members, went into the room and subsequently had the deceased or the suspect with them. Do you confirm?
I confirm that, yes.
Now, if we go to paragraph 10 of the same statement, it is noted thereon that I left the room where the suspect was and went to join Etienne, Quibus, Yaku, and Kershaw in the main bedroom. I conducted the search and recovered live ammunition and a leather firearm holster. I told the members to keep an eye on those exhibits and went to another room. That room was full of garden tools and other things. We found Mackenzie searching the cupboard that was having mags and tires, and he took them. We were all searching. At the kitchen, I saw Zander, Jean-Marie, and an unknown SAPS member, and they were searching. Do you see that, ma'am?
I do see it.
Do you confirm that in accordance with paragraph 10, Marius van der Merwe not only exonerated, for lack of a better word, applicants 3 and 4 being in the room, but on his own affidavit, he placed them in 2 completely different places within the premises pertaining to a search that was transpiring? Do you confirm?
Here is mentioning that they were in the main bedroom.
Correct.
Yes.
I'm saying, remember, according to this affidavit, it is the evidence, or the evidence of Marius van der Merwe that the suspect was taken into a different room. It was not labeled as a main bedroom. So what I'm wanting confirmation on, for interpretation that we are on the same page, is to ascertain that at the point when the suspect was taken into this bedroom with the 2 African SAPS members, it is indeed noted on this affidavit that Kershaw was in the main bedroom. She was busy searching, and where in, applicant number 4 was in the main bedroom busy searching, and where in applicant number 3 was searching in the cupboards and had subsequently removed tires and mags. Do you confirm that?
I confirm that, yes.
Thank you. If we then go to paragraph 12 of the same statement, ma'am. It is indicated after about paragraph 12, apologies, after about plus minus 30 minutes, I went back to the room. I sat on top of the bed, which was wet at that stage. I asked the suspect to show as to where the stock. I even begged him to talk in order for us to help him. He tried to respond, but I could see that it was strenuous on him. He spitted some liquid on my eye, then went out of the room to get water from the tap in order to clean my eye. As I was standing inside the kitchen, I saw Kershaw wearing the surgical gloves, and I asked as to what was happening, and she did not respond. On the basis of that paragraph, we can yet again confirm, this would now be the third time in one affidavit, that applicant 4 was not near the room where the suspect was allegedly killed and murdered. Do you confirm?
No, ma'am, I don't agree with that. If you say he was not near the room,
Yes.
because the deceased was tortured in one of the bedrooms. So, applicant number 4
Yes.
and 3 were sometimes in the main bedroom. So now, I don't agree if you say they were not anyway near.
Okay, so let me
Yes.
rephrase my question. Would you then confirm that this is the third paragraph within the contents of this affidavit, wherein it is noted, or rather non-existent, as to the fact that applicants 3 and 4 were in the room where the suspects, the now deceased, was subsequently being dealt with by Viandre and the 2 other police officials? Do you agree with that?
I agree with you, yes.
Thank you. Now, if I make reference to paragraph 19 of the same affidavit, it's noted therein on Saturday, the 16th of April 2022, and at about 6 o'clock in the evening, I received a call from Jean-Marie Eckstein using an unknown number. She said we should meet at Rose Tuli. I then did go there after informing Quibus. It was myself, Zandre Fritz, and Jean-Marie Eckstein, Yaku Hanekom, Viandre Pretorius. The meeting was chaired by Viandre, and they wanted to know if I was going to talk to someone about the death incident. I'm going to stop there. Do you confirm that with reference to this meeting that transpired, yet again applicants 3 and 4 were not present at the said meeting? Do you agree?
I agree with you.
Ma'am, if I can then ask you to refer to the statement of JM1. You will note that as per this affidavit or statement, many aspects or attributions have been blocked out. Do you confirm?
Yes, I do have JM1 now.
Okay, if I can refer you to page 12, paragraph 12, so it's page 3, paragraph 12. Are you there?
Yes, I'm there.
If I make reference to paragraph 12, it is noted, after the suspect mentioned the cash, the 2 unknown members from Brakpan SAPS and Viandre Pretorius then pushed the man into the second bedroom and closed the door behind them. Do you confirm the contents of what is noted on this statement?
Yes, I do.
And you will agree with me, we now, as per the evidence that I am subsequently, or rather the questions that I'm subsequently putting to you, this is the third statement pertaining to Marius van der Merwe, and yet again a further paragraph confirming that applicants 3 and 4 did not take part in this ordeal. Do you agree?
That's correct, yes.
If we then make reference to paragraph 16, that's on page 4, it's noted there, I picked up a wooden table leg that was broken from the furniture in the room, held his legs down with it so as to not touch him with my hands as he was wet. Viandre then continued tubbing him, with the one unknown Brakpan SAPS member helping to hold him down, while the other one was searching the drawers. On the basis of this paragraph, do you confirm that Marius van der Merwe himself was involved in the alleged assault, which may have subsequently led to the deceased, or the death of the deceased?
According to this paragraph, yes.
Thank you, ma'am. Apologies, Your Worship, if the court may just bear with me. And if I then refer you to paragraph 20 of the same affidavit on page 5, it says, I exited the house. I was joined outside in the garden next to the truck by Corbus and the others. Shortly after this, Viandre and Kershally joined us. I asked whether the suspect talked, apologies, and Viandre responded that he will never talk again. Do you confirm that that is what is relayed on the contents of this affidavit?
That's what you read, yes.
Thank you. Now, ma'am, having insights into the relevant statements and highlighting the prudent aspects and with reference to applicants number 3 and 4, would you agree with me if I am to say that with reference to the 3 affidavits that I have dealt with, okay, at no stage does Marius van der Merwe make reference to applicants 3 and 4 as being in the room where the suspect was allegedly assaulted and thereafter was deceased, nor were they in the nor were they involved in any form of what had transpired in that room. Would you agree with me in saying that I'm correct by what has been noted by the statements?
According to statements, yes.
Now, if we just go back, I do apologize, if we go back to CJVR5, it is paragraph 11 that I want to bring to your attention. It is noted thereon that I went outside and looked at the truck. One member took out the disc from the truck and we were waiting for those who were still searching. I went back and told Viandre that he should not forget that we still need to recover the stock. Are you in a position, ma'am, to confirm whether or not the stock was in fact found within the truck itself?
No, nothing was booked to SAP 13, so...
So is it safe then to deduce that the stock was already, let's say, removed or taken somewhere else by the time the truck was taken to the impound or for the necessary processing by the LCRC?
The truck was not impounded as well, ma'am. It was just left there in the house.
Thank you. Now, if for a second I'm not entirely sure as to whether I'm aware that there are many applicants before this court, and it entails a lot of reading with reference to their bail affidavits, hence why I've provided you with a copy of that. But in brief, it is the version of applicants number 3 and 4 that by the time they had arrived at the crime scene, there were a vast amount of members that were present, from SAPS to people dressed in civilian clothing to other officials and security companies. And at no stage had they seen the deceased himself, okay? That is their brief version as to what transpired, but as indicated, it is contained within the bail affidavit. So if for a second we are to accept the warning statements that were made by applicants number 3 and 4, I'm talking now the statements that were taken a year or two back, okay? Namely that they had not seen the deceased at any given point when they arrived at the scene, okay? And further, that there was no stock that was found on the premises at that time. does the possibility exist, and remember I'm asking the mere possibility, that this entire augmented plan had already transpired before applicants 3 and 4 had even arrived at the premises?
No.
Is that a possibility?
No, there is no possibility. If I understand you well, you are meaning that to say maybe there were other officials that were there before they came. That's what you're saying to me.
Correct. So according to applicant 3 and 4, it is their version that when they arrived, and many of the applicants actually, when they arrived at the scene, there were a vast amount of members that were present. Coupled with this is the aspect that we're sitting with a truck that has absolutely no stock. Now, it's common cause that obviously the stock must have been of great value if this entire ordeal had transpired. So my question to you is, if one is to accept the versions, given not only by applicant 3 and 4, but all the applicants before this court, that when they arrived, there were already members on the scene. We're sitting with a truck that's empty, and but for the amount of 500,000 being offered, which we are working on what is being said, is it not possible that this entire plan was augmented beforehand, and thereafter the necessary role players attended the scene as a means to use them as what one may say is an scapegoat? Is it not possible, ma'am? I understand you cannot confirm it, but I'm simply asking, is it not possible?
Yes, as you say, I cannot confirm it, but I will say to you it's not possible. Reason being, during trial, the state will be able to prove that they were the first officers to arrive in that house. There were no other police officials that came before in that house.
Sorry, ma'am, I apologize. So they, according to your evidence, they were the first officers to respond to this?
Yes, I'm not saying that. I'm saying applicant number 3 and 4, they, only the two of them. I mean, when I say they, I'm referring to the whole team.
Yes.
To say that team was the first team. There was no team that came before them.
Now, with reference to the aspect of count 2, wherein the charge of robbery with aggravating circumstances has been preferred, okay? As it stands right now during the bail proceedings, okay, are you aware of what subsequently happened to this alleged 500,000 rand that was offered by the suspect?
No, I don't know what happened to it.
And is there anything within the contents of the docket that is saying what happened to this money, or is the docket silent as to the aspect of the 500,000 rand?
No, we don't know what happened to the money. Only the applicants can tell us what happened to the money.
Now, if I refer you, Mrs. Masuku, to the handwritten statements again, CJVR 4, and I'm making reference to paragraph 7 of the referred to statement. I'm not going to read the entire paragraph, it is quite lengthy, but I just want to give attention to the first 3 lines, when it says, Yaku Hanukom, assisted by other EMPD members, went back into the premises and later came out with a yellow welding machine, and Mackenzie had tires and wheel mags with him. Do you see that?
I do see it.
Now, if we were to, for a second, accept the version that is submitted in paragraph 7, that indeed so applicant number 3 had left the premises with mags and wheels, would you agree with me that this aspect is tantamount to that of theft and not robbery, given that at no point was anybody held under duress at gunpoint, as is required when it comes to the aspect of robbery with aggravating circumstances, nor was anybody robbed per se because it was removed from the cupboard? So would you agree with me that at the very least it would be tantamount to that of theft?
No, I don't. I won't agree with you because the deceased was in his house when all this property was taken from his house.
But ma'am, you agree with me that at no point did applicant number 3, according to Maurice van der Merwe, at no point did applicant number 3 or 4 come into contact with the deceased when he was in the room with Leandre Pretorius and the 2 other officials. So I'm trying to understand how we can go from the attribution of these items being removed while he was being assaulted, but on the other hand, it being noted that applicants 3 and 4 weren't involved in that assault. That's why I'm saying, would it not be tantamount to the aspect of theft as opposed to that of robbery with aggravating circumstances?
No, I don't agree with you, ma'am.
Apologies, Your Worship, if the court may just indulge me. Ma'am, if we now go to your affidavit and with reference to your objection or the grounds noted for your objection in respect of bail, do you have that statement before you?
Okay, I will get it now, ma'am. Yes, I do.
Okay, if I refer you to paragraph, apologies, it's 15.1, wherein I'm specifically dealing with the section that governs the attribution pertaining to bail. You have noted therein that there is a likelihood of endangering the safety of the public or committing a Schedule 1 offence. You've gone as far, it's line 1, 2, 3, 4, line 4, wherein you've indicated the release of the accused poses a real risk to the safety of witnesses and members of the public. It is well known that most security companies in Gauteng province make their profits from demanding 10% of the value of the recovered stolen stock, emanating mostly from hijacked trucks. Therefore, it was understandable why such a big armed contingent of security cluster members converged into the deceased's home and tortured him to death. Do you confirm that that's what is noted on your affidavit?
That's correct, ma'am.
Now, ma'am, you would agree with me in saying that with reference to the aspect pertaining to that of security companies and the 10% within which they allegedly receiving when it comes to the recovery of stolen goods, you would agree with me that both applicants 3 and 4 are or were in the employ of the EMPD. They do not form part of private security companies. Is that correct?
That's correct.
And you would further agree with me that this matter ultimately emanated from the year 2022. Is that correct?
That's correct.
And when the investigations had commenced, and despite applicant 3 and 4 having full knowledge as to the aspect pertaining to them being under investigation, there has been no endangerment of the public, and with reference to applicant 3 and 4 in their personal capacity. Am I correct?
You are correct, ma'am, but can I expand on your
Yes,
questions?
you may.
Yes. Sorry. As you have started to say by the comment that they were employed by EMPD.
Yes.
I agree with you. Then, during their employment on the day of incident, both applicant 3 and 4 were off duty. They were home when they received that invite to attend to this matter. And then applicant number 4 informed applicant number 3, who was at home because it was his partner's birthday and he was having a bit of some alcohol. They left their premises and proceeded to this place where the person was later killed. And then when they were off duty, what was their interest in attending to such? Because there were other metro officers that were on duty on the night that were supposed to be called to come and help. So for them to go and visit that crime scene while they were off duty, they were having some interest.
But is it not safe to say, ma'am, that as per your previous testimony, it is the ethical duty of a police official to act accordingly? So if, as was the case here, a message is posted in a group where assistance is required, is it then to say that despite one being an EMPD official and being off duty, the message should just be ignored? Am I understanding it to be that way?
Being a police officer, or if I say police officer, I'm including them
Yes.
as metro officers. Yes, you cannot ignore a crime when it's happening in your presence, or you are aware of something that is happening, or the assistance is being sought from you to say come and help. But if you can check as to how far is applicant number 3 and applicant number 4 staying from the place of incident, it was too far for them to travel all the way when they were off duty. It was for them to relate that message to their supervisor, which was applicant number 5, to say, you must, this is the message, can you please allocate members on duty to go and help? Not for them to come all the way while they are off duty and then later on somebody was found dead.
Okay, so with reference to the answer that you've provided, you've indirectly in your affidavit provided a motive to that of security companies on the surmise or the basis that they receive 10% of whatever stock or hijacked items have been recovered. What motive then do you believe an EMPD official would have in engaging in a crime of this magnitude, in your opinion?
This incident was going to involve money. Unfortunately, it went wrong because Mr. Mbense died before he can give them the stock. If they had received that stock, then they were going to have to get whatever that was going to be due to them. The state, during trial, will prove that.
But you agree with me in saying that on your own version, we don't know if where the 500,000, the aspect of the money that was made noted by the deceased, we don't know what happened to that money. Quite frankly, that money may never have existed. Would you agree with me?
We don't know what happened to the money. We don't know if there was money there. We don't know because
you
we
agree
never
with
found
me?
any money.
So you agree with me, ma'am, that we don't even know if this 500,000 actually even existed, correct?
That's why, ma'am, I'm referring to the stock because
No.
they are for them to go and attend to that scene. It's
Yes.
because they were told that there was armed robbers
Yes.
who were a lot of them there in that premises, and then there was a truck full of stock that was worth millions. So for them to wake up in their own homes to go all the way there on that night, then they had some motive.
So your testimony is with reference to the stock alone, correct?
Not to the stock alone, because remember, I don't know if they got the stock, if they were going to sell it or they were going to take it home.
No,
I don't even know
I'm
what was
making
it
reference
exactly.
to the stock and not this alleged 500,000. That's what I mean.
Oh yes,
Okay.
that's correct. Yes.
Now, with reference to paragraph 15.2, you indicated, or rather one of the further grounds is the seriousness of the offence and the severe sentence that would be imposed if found guilty. Now, I know that you've been asked the question before, and I do apologize for the repetition, but for purposes of my case, I obviously need to canvass more or less the same questions. You confirm, or rather in line with your testimony, that both applicants 3 and 4 handed themselves over. Is
That's
that correct?
Yes.
And you further confirmed that despite them having knowledge as to the investigations from the year 2022 up until the year 2026, thus meaning that a period of 4 years have lapsed, neither of them have changed their cell phone numbers, have subsequently immigrated overseas, and more specifically applicant number 4, who then possessed the passport and could easily flee the country, neither of them attended to that. Do you agree?
I do agree.
And you further agree with me that applicants 3 and 4, and where information has been requested or required, they have in fact cooperated with EMPD and its team. Is that correct?
I agree.
If we then go to paragraph 15.3 of your affidavit, I'm going to refer you to the second paragraph, wherein you noted there we have, okay, so the deaths of Jaco Hanekom, Mr. Khoza, and Marius van der Merwe, together with the death of Viandre Pretorius, create legitimate concern regarding the safety of the remaining witnesses. One of the witnesses, Etienne, previously received death threats, and he was in a secret location for a period of time. You confirm that that is what is relayed therein?
Yes, what you read, yes, that's what it's in the statement.
Now, ma'am, with reference to the subsequent killing of Marius van der Merwe, am I correct in saying that there is currently, at present, as we sit in court today, there is already a suspect in custody on that matter, and with reference to the attribution of him having killed Marius van der Merwe, which person is not sitting here as an accused or an applicant before court today? Do you agree with me?
That's correct.
And you further agree with me that with reference to Jaco Hanekom as well as Khoza, that none of the applicants, as it stands right now, none of the applicants before this court have been charged with the murder or attempted murder, pertaining to that of Jaco Hanekom and Mr. Khoza. Do you confirm?
I do confirm that.
Now, the aspect of this particular 15.3 is noted as section 60, subsection 4, subsection C, wherein, and I want to highlight it because I believe it's very crucial and important. It says the likelihood of influencing or intimidating witnesses or concealing or destroying evidence. Now, the concern that I have, ma'am, is that you have on your own affidavit informed not only the applicants before this court, not only the magistrate presiding over this matter, nor the media. You on your own version have put forward the identity of your witness. Up until we were provided with a copy of your affidavit, it is my instructions from my clients that the only witnesses they could possibly think were involved were those that have already subsequently passed away. Even in the matter that was dealt with and adjudicated over in Joburg, there was never an indication that Etienne van der Walt was made a state witness. It was recorded duly so that representations were submitted and the matter was withdrawn. On your own version, you have provided us with the identity of your star witness. Now, why I'm putting emphasis or focus on this aspect is, why would one elect to do that if there is this concern around the aspect of intimidating or influencing witnesses?
Because he was already intimidated. Hence, during evidence in chief, Mr. Thulani Magagula's statement was read as the investigator who had interviewed this witness during the period when his life was under threats.
But ma'am, you agree with me that when it came to the Maklanga Commission, we had witness D, we had witness K. Why couldn't we have witness E?
And that's
Why
not,
did one need to disclose the identity if, according to the state, the applicants before this court will intimidate or may intimidate or influence a witness? I'm just trying to understand the logic pertaining to putting this person's name out there, when in actual fact, not only the investigating team, but the state themselves fear that the applicants are going to intimidate or influence them?
I think that's for the prosecution to answer that, to say why is he mentioned by the name.
So you would agree with me that it may not have been the best thing to do in opposing is to make specific reference to this person. Would you agree?
Ma'am, if you say, should I agree with you, so that means you are supporting me to say this witness' life will be in danger.
No. I'm saying for purposes of concealing the identity as witness K and witness D. Because remember, that is one of the grounds upon which the bail is being opposed.
Ma'am,
Whereas if we don't know who the witness is, how can it be alluded to?
there is no way that even if we said witness G or witness or whatever alphabet we give him,
Yes.
all the applicants will know who we're talking about. Even if we hide his name, they know who we're talking about. So for the Madlanga to hide, they are hiding it to the public. Not that they are hiding it to everyone. Even this public, they don't have any interest in going after our witnesses. The only people we are looking at is the applicants in
But-
this matter.
But you would agree with me that on the basis of your own statement, the state, alternatively IPID and its investigating team, have given us the identity of a witness. Would you agree?
No, we didn't give you. The witness was known by your applicants. We are not giving it to you. We're just confirming. They know who our witnesses are.
And I'm going to deduce that you are of that view. You don't have proof that my clients knew this? Or rather, applicants 3 and 4. Apologies.
Okay, can you just repeat that? I don't
I
understand
said-
what's the question.
Am I correct in saying or deducing that it is simply your opinion that applicants 3 and 4 knew who the Section 204 witness was? Or do you have evidence to confirm this?
It's not that I'm assuming they knew. They know.
Okay.
They know.
I will leave it at
Yes.
that. Now, within the contents of the same affidavit, it's indicated, I did already read it, but I'll just read the last part again. One of the witnesses previously received death threats and he was in a secret location for a period of time. But for stating that death threats had been received, no further information has been given. Were death threats received from applicants so and so, or were death threats received as a cumulative aspect? Or are you in a position to say that applicant, for example, 3 and 4 had subsequently portrayed death threats untowards your Section 204 witness?
Ma'am, there was a statement of the investigating officer whereby a few paragraphs were read in support of this paragraph. Yes.
So I'm correct in saying that it obviously forms part of the content of the evidence that forms part of this record. Is that correct?
That's correct.
Okay. Apologies, Your Worship, if the court may just bear with me. Now, with reference to paragraph 15.3, if I may just refer you to the affidavit again of Morris van der Merwe, the one that is labeled CJVR5, and I'm referring to paragraph 13 of the said affidavit.
Yes, I'm there.
Okay, as a means just to attempt to shorten the question, I'm going to refer you to line 1, 2, 3, 4. So it's line 4 where it says, and Viandre further said how were we going to contain all that Jean and Zander said they were going to fetch the firearm because they were planning to shoot the suspect who was deceased, and they were going to plant him with a firearm in order to make it look like self-defense. If you go then to, it's 3 lines down, as we were sitting there, Viandre told us that if we talk, he was going to kill that person himself. Do you see that?
I do see that.
Now, would you agree with me, or would I be incorrect or correct to state that if one is to peruse all of the affidavits deposed to by Marius van der Merwe, it is only the name of Viandre Pretorius that is brought to light insofar as threatening the remainder of those that were there, to say, if anybody says anything about this, I will kill you myself. Do you agree with me?
I don't agree with you, but I just want to check as to which part of the statement whereby it will be referring to one of your applicants.
Okay.
Okay. If you go to paragraph number 18
Of the same
of
affidavit?
the same statement,
Yes.
and then you count from down, it's the
Yes.
3rd line on paragraph 18,
Yes.
where it says, Keisha then said, it was done, and no one should talk about this on the phones.
Yes.
Yes, I will stop there.
Okay.
Yes.
But if we proceed with the rest of that paragraph, yet again it said,
Okay,
Viandre emphasized that if we talk about this, someone will die.
that's correct. I agree with you.
So all I'm saying is within the contents of all of the affidavits deposed to by Marius van der Merwe, Viandre Pretorius was the only and solely person that had portrayed the aspect of death should anybody talk about what allegedly transpired.
Ma'am, applicant number 4, when he mentioned to say it is done, it was done, and no one should talk about this on the phones,
Yes.
that sounds like a threat.
How does it sound like a threat? Please, allow me to understand.
Yes, we had just committed crime,
Yes.
dumped the body of a human being into the dam. We come back on the meeting, we sit together, then we're saying it is done.
Yes.
No one must talk about this on the phone.
Okay, but within the contents of that, so the aspect of planning a surprise birthday party, let us not talk about this on the phone. Just now someone overhears our conversation. It's not tantamount to a threat, ma'am. It's an aspect of we do not canvass this aspect. Nowhere within the contents of that sentence does she mention anything as to the aspect of somebody will die or people will die. She just simply says, according to this affidavit as we're going on, that no one must discuss it over the phone. The only threat that ever came from any of the participants or whoever it may be was that at the hands of Viandre Pretorius, who even went as further as to say that if anybody is to speak about this, I will go to prison for killing that person.
I agree with you, ma'am.
Thank you, ma'am. Now, if I may then refer you to the, apologies, I just want to get the right affidavit. If I refer you to JM1, it is paragraph 21. Paragraph 21, which is on page 5.
Yes, I'm there.
Okay. If we look at paragraph 21, it specifies there, or states, a discussion between the law enforcement members then took place as to how to deal with the scene. Kershally tried phoning a paramedic to declare the suspect dead. Viandre approached me and informed me, being now Marius van der Merwe, that he will phone General Khan to fix this. He then responded and said no, as this is his, Viandre's problem. He responded and said it's all of us in this, and if anyone talks, he'll go to prison for killing them. Further, if we go to paragraph 22, reference is made to, I walked away as Viandre and I had had issues in the past. Now, the reason I brought your attention to this particular paragraph in this particular page is more so in line of the fact that yet again, in a second statement from Marius van der Merwe, we have the aspect of Viandre Pretorius yet again harboring the threat of death should anybody talk. Do you confirm?
Yes, I confirm that, ma'am. And he also confirms that Kershally was aware that somebody had died as she tried to call the paramedics to declare the suspect dead.
Yes, we have noted that, ma'am. It's there.
Yes.
That's why I read it. I'm not here to misrepresent the contents of the affidavit.
Yes.
And you would agree with me that on the basis of what has been conveyed by Marius van der Merwe, the relationship between himself and Viandre Pretorius didn't appear to be one of or on friendly grounds or of a friendly nature. Would you agree?
According to the statement, yes.
So does the possibility then again arise that maybe, just maybe, Viandre Pretorius may have had or been involved in the assassination of Marius van der Merwe? Just on the basis of this statement. Is it a possibility? That's all I'm asking.
Yeah, it's possible.
Thank you. Apologies, Your Worship. I'm just checking my notes. So, in conclusion, ma'am, apart from the aspect, I mean, my learned colleagues have covered a vast amount of this matter, and I don't intend to reiterate each and every question, or we will be here for months on end. But before I request or ask the court to approach my clients for any further questions, I just want to ascertain from you that on the basis of Marius van der Merwe being the only witness that existed at this point in time, applicants 3 and 4, despite them even confirming on their own versions that they were at the premises, Marius van der Merwe has indeed confirmed the attribution pertaining to the fact that at no point was applicant 3 and 4 ever in the bedroom where the suspect was with Viandre Pretorius and the 2 unknown African SABC males. Do you confirm?
I do confirm that.
Your Worship, may I be at liberty just to approach applicant 3 and 4? Thank you. I'm indebted, Your Worship. Ma'am, there's just one question that I have, which my clients have brought to my attention.
Yes, ma'am.
Insofar as the aspect, or your testimony rather, that on this particular day in question, both applicants 3 and 4 were not on duty. As you correctly indicated, applicant 3 was with his wife celebrating her birthday, and applicant 4 was at her place of residence. It is my instructions that the reason that they had subsequently attended to the scene on that day was for purposes of overtime. Are you in a position to clarify or give us any form of input or commentary on that aspect?
No. In their statement, they never mentioned that. That's a new thing that I must follow. their HR will give me their claims of that overtime of the day in question.
May I then just ask, just as a sideline aspect, because it's not a common aspect in all jobs, okay, some jobs just expect you to put in more hours and not get further overtime. But when it comes to EMPD officials, do they receive overtime? Do you know?
Yes, they do get paid for overtime.
Thank you very much, ma'am. Your Worship, I then have no further questions for this witness.
Thank you. Right, we are left with 17 minutes post time. And then it is clear that even if the attorney for applicants number 5 commences his cross-examination, he won't finish in 17 minutes time. Then it is an opportune time to postpone the matter. Have a date in our
Your Worship, let me start.
Counsel for the state.
We did not, Your Worship, canvass the next date. We didn't get that opportunity. Your Worship, I don't think that we'll be pushing. We'll be pushing at the court if we can just voice out as to what day. Can this be postponed to?
I remember I called you and Mr. Van Heerden in chambers.
Yes,
and I
yes.
indicated to you that Mr. Van Heerden will be the spokesperson for other developers.
Yes, yes.
Do you know whether he communicated the same?
Your Worship, may I address, as we did canvass it earlier, when Mr. Van Heerden was still in attendance before he had to leave, we had discussed Monday, the 31st of August. We did not liaise the date with our learned colleague for the state, and obviously we do apologize for that, but it's more of an aspect getting all of us to be in attendance. So I'm not too sure whether my learned colleague is available on the 31st and whether the court can accommodate the 31st.
Your Worship, I remember that the court did talk about the Monday. That is a bad day for this court. And asked us to start looking from the 1st, that week of the 1st to the 4th, or the week of the 14th to the 18th.
Right. The court will adjourn. Professor, I hear some sounds here. That's
Yes,
a
sir.
good thing. Anyone who makes noise will have to make noise will have to remove it. Court adjourns.
All rise.
I'm not sure which one it's been on.
Diego. Thank you, Worship. The court convenes after that short adjournment. Worship, we did put our heads together. Monday, I can make sacrifice. I want to be here, Worship. And my friend, I think, agree on that Monday. Because the clerk has told her that it's not the same list that the court normally have.
You confirm that advocate
Van Wijngaard, Your Worship, yes, I confirm. Is it Monday? I
Mr. van Heerden, Advocate Wilkins, Mr. van As,
I confirm, Your Worship. Thank you.
matter postponed till Monday, 31st August, for further bill applications. All 6 applicants will remain.
Your Worship. I'm sorry, Your Worship. They confirmed the date, but they didn't tell me the date. I don't think I'll be available on Monday because I'm traveling outside the province. So for me, for the Monday, I don't think it will work out for me.
Counsel for the states, you did not.
Your Worship, I did not canvass it. I took for granted. I apologize to Ms. Masu, indeed. I did not canvass with the to the next date.
Memasuku, will you please approach?
And then see, Your Worship, when is she going to be available? Yes, Your Worship.
So do you need me to adjourn?
No, Your Worship. No, Your Worship, it's not going to be long.
Yeah, right. While the counsel for the state is still consulting with the witness,
Thank you, Worship. I have instructions. She's attending a funeral at home in KZN, so any day from Tuesday, she'll be here. From Tuesday. Any day from Tuesday, the 1st. It's fine. Your Worship, it's as if we are all suggesting the 11th Thursday. You're sorry, Your Worship. 3rd. Is it 3rd? Yes, the 3rd, Your Worship. 3rd. Yes.
Excuse me, Your Honor, may I approach the court?
Bible. What is this now? We can't do this.
Sorry, you should be excused.
no, Mr. Nell, you have to sit down. Right. This is now for the second time.
Yes, Your Worship.
Earlier, when a postponement date was proposed, I had an uproar among the gallery, and then a lot of noise was caused there to the extent that I informed the court orderlies to do their job. I just want to bring that under the attention of the members of the public, that if they proceed like that, this court may order that this bail application proceeds in their absence. This is a warning, and if this situation is repeated, I'll order it. Thank you.
The 3rd, Your Worship, is fine. The 3rd of
Right.
September.
Your Worship, I've indicated to my learned colleagues that I'm engaged in another matter between myself and Mr. Nell and his other partner. We will make a plan because we don't want to be the problem in this matter. Maybe just get an indication pertaining to the time. Because that is a bit of a problem. We all make ourselves available for 9 o'clock, and we appreciate the court's position pertaining to the hefty court role. If we can maybe arrange for 11 o'clock, so that we can maybe deal with the other matters that we have, and then we can be at court at 11 o'clock.
Ms. Kiki?
Thank you, Worship. Your Worship, I do confirm that I am available on the 3rd of September. I will also be in detail with reference to the time, Your Worship. I do have a postponement on the 3rd of September, but in the event that the court orders that we be at 9, I will then make necessary arrangements for that matter, Your Worship.
And then Mr. Van Heerden Jr.
That is suitable.
I noticed that Mr. Van Heerden Sr. is also present in court.
Oh, that is
back.
From the sidebar, I also confirm that that will also suit me.
Advocate Wilkins.
I confirm that is suitable.
Matter postponed to the 3rd of September 2026 for further bail hearing.
There's one more request, Worship. Accused number 5 is appearing in Chimistin tomorrow. We have made an arrangement for him to be kept in Brakpan Magistrate Court. There's a letter to that effect. That is it. Worship, it is from the correspondence from the office of the station commander at Benoni, dated the 27th of August 2026. It is the approval for the detention of a male suspect from IPD. Paragraph 1. This office hereby confirmed that the IPD request to detain Mr. J.D. Mkhwanazi on postmark cast 26203 of 2023 on a bail hearing is being accepted to accommodate him for the period requested. 2. We therefore request that the suspect cannot be visited out of visiting hours, that is 11 to 1 in the afternoon, like all the suspects detained in the facility. 3. The suspect will be provided by the station with food, except where there is specific medication prescribed by the doctor will be allowed. Signed, Worship, by Colonel S. Indaba. Thank you, Worship.
Right. All 6 applicants will be kept in custody without bail. And then pertaining to applicants number 5, Mr. J.D. Mkhwanazi will be kept at
In Benoni, Worship.
Benoni Police Station.
The court is yours.
Thank you. And the court adjourns.
All rise.
So